Good afternoon, ladies and gentlemen. Welcome to our international speaker series. My name is Angela Zhang. I'm the director of the Philip K. Wong Center for Chinese Law. Today, I'm extremely pleased to have Professor Matthew Erie from Oxford University to join us to give us a talk on his latest paper. This is actually the second in-person event we have held this semester, and I'm thrilled that we can do it with a hybrid mode with both online participants and offline faculty members and students. Before we start, let me give a very brief introduction of Professor Erie. He is an associate professor at the University of Oxford, as well as an associate research fellow of the Socio-Legal Studies Center there. His research synthesized two types of interceptions. The first is between the Anglo-American common law and Asian law, and the second is between law and the social science. He's trained as a lawyer, has years of practice experience, and also has a PhD from anthropology. And his work addresses a wide range of issues like law and capitalism, alternative global orders, comparative international law, socio-legal methods and theories in China. And I'm also very happy to introduce my wonderful colleague, Jack Cronkey, as the discussant for today's talk. So Jack is an associate professor of law at the University of Hong Kong. And interestingly, Jack also has a PhD, I think, in anthropology. So you guys have a lot to talk about. And Jack teaches, as you know, Jack teaches property law, equity and trust at our law school. And he also does a wide range of research topics and is a I see him as one of the most intellectual member of the faculty. So without further ado, let me give the floor to Matthew.
Thank you very much, Angela, for the introduction. Thank you for having me. I also want to thank Dean Fu for the invite. It is an absolute pleasure and privilege to be here. One thing that I realize is that pre-COVID, I really took for granted the ability to travel and to go to other universities and engage with colleagues. And another realization is that, at least in my view, the best scholarship is not produced sitting in your living room staring at the wall for 2.5 years. Rather, it's by engaging with colleagues and partaking in dialogue and debate. So in that spirit, I very much look forward to the questions and the comments in the Q&A. So this is really part of a larger project. I have to kind of foreground that. And the challenge that I face in presenting it to you is how much of that larger project to present versus how much of this particular paper, which is just kind of a segment or a splice of that larger project, which one to focus on. And my approach today, I'm not sure if I struck the right balance, is to kind of give you a broad sort of introduction to the conceptual frame of the larger project, so that you can position this paper within that larger project and then focus in on that particular single paper. So to give you the background, I've been very fortunate to be the principal investigator on a 5-year research project funded by the European Research Council in Brussels called China Law and Development. And the focus of this project is to try to understand the role of law in China's global development. And so there's two aspects to that. One is China's engagement with international law, with a primary focus on private international law concerns, trade and investment in particular, but also how China is engaging with challenging regulatory environments in host states. And we're focusing primarily on low-income, middle-income countries from Southeast Asia, South Asia, Central Asia, Africa, Latin America, and Eastern Europe. I will say that we started this project in 2019. The world was a different place then. We did not know that the largest pandemic in 100 years would hit at the end of that year. Certainly, the pandemic has affected the project. Just like everybody in this room, we've struggled. We've had to adapt, and so we've kind of incorporated the pandemic as an object of analysis into the project. In fact, we have a special issue coming out in the Asian Journal of Comparative Law on this particular topic of how Chinese outbound capital is grappling with the regulatory effects of the pandemic, both within China but also in host states. So we're all adapting. I want to begin with sort of a kind of nod to the particular perspective that we take. So part of what we're doing in the project is trying to decenter the dominant sort of Western approach to the comparative analysis of Chinese law and governance. And the way that we do that is by engaging with partners in host states. So we've incorporated, and this is also a result of the pandemic, we've built out a tier of the research design, which is composed of primarily junior scholars, including a member of this faculty, who are from host states and also from the home state of China. And they are collecting data, analyzing data, and conducting their own projects under the larger umbrella of our CLD, China Law and Development Project. And again, the idea here is that we're diversifying, we're pluralizing perspectives on Chinese law and governance with the ambition that we can learn new things about these topics. One thing that we do is we provide a platform for these scholars to write what we call research briefs, which are really sort of a snapshot of their ongoing research projects, with the idea that we can support what they're doing and build out these conversations and help improve their own ongoing projects, because I think there's a lot of amazing potential with these scholars. And also one thing that we've noticed is in many of the host states, again, as I mentioned, from Southeast Asia to Latin America, there's frankly a paucity of knowledge about Chinese law and governance. And so part of what we're doing is engaging with interlocutors, which includes governmental representatives, civil society, think tanks, and academics in these countries to hopefully share our knowledge and resources. And it's very much a dialogue that we're engaging in with these partners in the host states. So we're working on a number of outputs. You can see our website for kind of what we've done to date. I'll just mention a couple of things we're working on. We're working on a casebook, actually, on Chinese outbound investment, which is comprised of empirical cases that assess the impact, the good, the bad, and the ugly impact, if you will, of Chinese outbound investment in these jurisdictions. That's one project we're working on, and a number of monographs as well, which are sort of the results of long-term fieldwork in a number of different countries. One outgrowth of the project is something that we call inter-Asian law. We are very fortunate to hold a workshop in Taiwan just last December. The idea of the Inter-Asian Law Project is to assess how Asian jurisdictions are shaping legal development in other Asian jurisdictions. Again, we're used to thinking about comparative law in terms of west to east, north to south. But what we find is actually there's quite a bit of interaction and learning, co-learning between and amongst Asian jurisdictions, in particular Japan, India to some extent. China and Singapore are very active in shaping legal developments in other Asian, in other neighboring jurisdictions. And so we're creating a network to assess some of these developments, and it's been really exciting. And this is something that we are invested in and interested in developing further beyond the edited volume that we're working on. As I mentioned, the project has undergone revision as we're all adapting and adjusting to the new reality, which is shaped by COVID, but also by the evolving geopolitical terrain. And so while the initial project was very much focused on the China Global South relationship, the US is increasingly mediating or intervening in this relationship. And so the analysis cannot exclude the US. And so we see this in terms of the severing of Sino-centric global supply chains, competitive development assistance, regional soft power battles, so on and so forth. And we're working on a series of papers that analyze this trilateral relationship and also the bilateral relationship, the U.S.-China relationship in terms of its impacts in other neighboring states. So all of this is kind of by way of background to help you position this particular paper. So let me begin with the focused paper now. So given the amount of trade that China is participating in and its significant volume of investment, even if that has declined in recent years, China is clearly dealing with a large number of foreign-related legal issues, including disputes. And this requires Chinese legal authorities to build out a legal system that can address these foreign-related legal issues, the external aspects. This is increasingly subsumed under a rubric of what's called 世外法治, which I'll translate as foreign-related rule of law, define that in a moment, which I think has a certain orientation that appears, I will argue, different from the orientation of China's own domestic legal reform. So the question that this paper is interested in grappling with is when we look at the external facing aspects of the legal system, again, this is foreign law, international law, cross-border disputes, foreign lawyers, foreign judges, etc., versus the domestic or internal ones, primarily domestic transactions and disputes. Do they need to demonstrate a degree of compatibility, if not convergence? There's a body of literature, theoretical literature, which suggests no, they don't need to demonstrate that convergence. So, for example, the core idea of dualism and international law, which suggests that international law and domestic law are separate or separable. Legal dualism, which grows out of the literature and legal pluralism, the idea that there are dual or plural legal orders which exist in the same social field. We see this oftentimes in post-socialist states, post-colonial states. The idea of the dual state, right? Frankel's notion of the normative versus the prerogative state. They all suggest that essentially, while there may be tension, there's no kind of existential contradiction, that these different normative systems can coexist. My intervention is that contrary to these theories, I would suggest that more often than not, we see a kind of convergence between the external and the internal. And when there is no congruence, divergence, especially if it's an increasing or widening gap, presents a problem in terms of the sustainability of the legal system. More specific to the case of China, I want to argue that the nature and directionality of the externally facing legal reform cannot easily escape the corresponding features of the domestic legal system. And I do this through the study of 世外法治. I draw from an eclectic mix of literature, legal realism, decolonization theory, critical race theory, and comparative law. This paper is very much informed by my earlier work on the Chinese domestic legal system, and the goal is to kind of link up some of those insights and observations with what's happening now in this effort to build out the externally facing system. So let me now move to the comparative case studies and the issue of why they're selected and why compare. So it's clear that the US and China, as the two dominant economies in the world, have a massive footprint in the global economy, and by extension, their legal systems are shaping international economic law. There is a well-documented literature that the US has very much informed IEL. There's this idea of the Americanization of international law in particular, but China also is an active player in this field, potentially increasingly so, through its trade and investment, bilateral investment treaties, its involvement in the World Trade Organization, its own practices of soft law and MOUs with partner states. Now, under the US-China trade war, we see elements of lawfare, right? The weaponization of law, of sanctions and regulations. Oftentimes in the media, the takeaway is that the result is a kind of decoupling, a sort of separation. And I think it's fair to say that while there are aspects of this in particular industries, so technology, which Angela has worked on, and social media platforms, there's no question this is happening. actually, the economic relationship is quite intimate. I think the numbers for the first quarter of 2023 suggest that the trade volume is set to break records. So there's still this very intense economic relationship between the two countries. And I would say even further that the legal systems now are actively shaping each other. So it's not just this process of fragmentation and deglobalization, although there are aspects of that, but rather I think there's this heightened interaction between the systems, which is quite fascinating. You see this obviously through tariffs, the kind of mutual imposition of sanctions, the blacklist or the entity lists, investment screening, the various types of injunctions, and China's mimicking of U.S. extraterritoriality and long-arm jurisdiction. So all of this is sort of happening as we speak, and it suggests that, again, there is this high level and intensity of legal interaction between the countries. And this may be a kind of novel legal interaction because there's a learning and there's a mimicry, but in some ways it's used in aggressive and assertive fashion to try to frustrate the integration of the adversary into the global economic system. So that's, again, sort of a stepping stone to understand why these particular jurisdictions are important to assess. And I want to now hone in even further in terms of how we might begin to think about analyzing comparisons between a legal system. And this is the question of how the internal and external dimensions of a legal system operate either in unison or potentially at odds. I think there's different ways to make this comparison and to assess the relative compatibility of the external and internal dimensions of a legal system. You could look at, for example, provision of justice between the internal and external. You could look at efficiency concerns. I'm interested in the question of difference. So when I mean difference, I'm using a very broad understanding of difference. I'm interested in different types of law. So not domestic state law, but essentially foreign international law, but also subnational sources of law, customary law, etc. As well as the second element is legal practitioners. So legal authorities and professionals who are involved in the process of making law and making decisions about the law. And I draw on a broad literature, both in sociology of law, comparative law, and political science. So Tubner, Tamanaha, Ralph Michaels, Elizabeth Papanelli, Charles Taylor, and many others to flesh out my particular approach to difference. I'm interested in two types of difference in understanding how states deal with difference, which I would argue determines outcomes in terms of whether or not there are trends towards globalization or deglobalization. So the first is the rules themselves. So this is private international law, or what in common law is called conflict of laws, that is recognition, enforcement of foreign judgments and arbitral awards, the role of foreign law, the place or status of foreign law in domestic courts, and so on. And then the related issue is the rule makers themselves. So this would be, for instance, foreign judges sitting on domestic benches, the role of foreign arbitrators and the list of arbitration commissions and centers, and also the legal market for foreign lawyers, as well as foreign law students, an important actor in and of themselves. So the analysis is cutting across a number of traditional domains of law. So it involves constitutional law concerns, what's called foreign relations law, certainly international law, multi-jurisdictional transactions, transnational litigation, judicial cooperation, law and development, and in other areas of law. So what about the U.S. Approach to difference? What is the U.S. approach? And I think it's fair to understand it as an example of a certain type of exceptionalism. How does the U.S. legal system treat difference? I think it has a kind of mixed record. On the one hand, to take one metric of integrating legal difference into a domestic system, we see a robust use of foreign law in U.S. courts. So that's just results. It's reflected in U.S. case law. However, at the same time, and complicating that, there's a very strong conservative ideology that operates in the U.S. and U.S. courts in particular, that citations to foreign law are unconstitutional, that the U.S. legal system is different, it's special, and that it should not be borrowing from, using from external legal authorities. I would say that this logic is to some extent mirrored in the extraterritorial application of U.S. law, so U.S. law outside of the jurisdiction of the U.S., contrary to the presumption against extraterritoriality, right? So we see long-arm jurisdiction being used quite extensively by the U.S. Government, the Foreign Corrupt Practices Act, the Alien Tort Statute, and other sources of law. We see this in antitrust law. We see this in state legislation, which is exempted from the presumption against extraterritoriality. The broader point is that there is a general consistency between these two dimensions, right? So this kind of skepticism towards the role and presence of foreign law in U.S. courts, and yet the ready application of U.S. law outside of the home jurisdiction. Scholars have a number of different ways to understand this process, what I'm calling U.S. legal exceptionalism. The first would be looking at the rule makers themselves. And the broad idea here, which I think borrows from old school American legal realism, is that there's a causal link between the identity of the lawmaker and their legal thinking. So thinking back to Jerome Frank, but also reflected in more contemporary law and economics, scholars like Lee Epstein, Richard Posner, and others, there's strong empirical evidence that categories of race, gender, class, educational background, political ideology, these can be formative of how judges are coming out with their decisions. There's just one metric on the pie chart on the left side, which is from the American Constitution Center. They use data from the Federal Judicial Center. This is circa 2021. Amongst the Article III courts, that is the Supreme Court and federal courts, upwards to nearly 70% of judges are Caucasian. This reflects Trump's appointments. So Trump was extraordinarily active in appointing federal judges. Upwards to 25% of the entire federal bench was appointed or reappointed during his term. 92% of his appointees are white and 76% are male. Oftentimes they're politically conservative, and as a result, we've seen this reflected in certain decisions by Article III courts. One could name a number of cases, but Dobbs would be one of them in terms of eroding the rights of women and minorities. That's one particular analysis that scholars have taken, again, focusing on the rule makers. Another analysis is focusing on the rules themselves. And so here I'd cite Maggie Gardner's excellent article on parochial procedure, where she argues it's not so much about the judges or what they had for breakfast, which determines outcomes of decisions, but rather the rules themselves. And she would argue that there's kind of this ingrained path dependency that militates against greater recognition of foreign law. This is ascertainable across a number of areas of law in terms of discovery of foreign evidence, foreign non-convens, service of process, and other areas of legal procedure. I would say that probably it's not an either or issue, but some degree of kind of integration or overlap between the two operating together. As a result of legal exceptionalism, or because of it, we do have a longstanding critique of this approach to foreign international law. And this stems from an overlapping body of literature that suggests that there is a kind of racial empire that is a result of the U.S.'s approach to forming international economic law. So the critical race theorists, the scholars of third world approaches to international law, and a new body of literature from IEL, International Economic Law, James Gotti and others, which would suggest that these issues of race are formative in terms of the outcomes of the U.S. approach to governing international law concerns. So the idea here is that essentially there's a kind of racial empire which is baked into the U.S.'s approach to international economic law, which ultimately then would serve to marginalize or sideline minorities, and especially those from the global south. And so, as we know from the Bandung Conference onwards, there is a longstanding critique that developing states are not first and foremost in terms of organizing international legal institutions, and they're disadvantaged accordingly. And there has been a response over the years in terms of many developing countries in Africa, South Africa, and others that have responded in terms of disengaging from their commitments under bilateral investment treaties. So there is this ongoing critique, and it is having a real impact in terms of how these states are organizing themselves in terms of commitments and obligations under international law, which they perceive to be essentially, pro-global North in the U.S. in particular. Now, an important point is that China has been formative of this longstanding critique of U.S. legal exceptionalism. So if I may quote Mao Zedong in a 1963 article in Renmin Rubao, I'm going to give you the English translation. The fascist atrocities committed by American imperialism against Black people have exposed the essence of so-called democracy and freedom in the United States, and exposed the interconnection between the reactionary domestic policy of the U.S. government and its aggressive policy abroad. To some extent, this language, it mirrors the current moment of the Race Me Too movement. In terms of Mao's critique of the double standard of U.S. democracy, it also resonates with the body of literature that critiques this. I think of, for example, Mary Dudziak's 2001 study called Cold War Civil Rights, where she argues that one reason why the U.S. government the federal government ultimately took on efforts to support Black rights and civil rights during the 1960s and 1970s was because of exposure to external and foreign critique in the form primarily of Soviets. And so Mao's language sort of echoes this language at the time. I think this critique maybe potentially overvalues the foreign involvement in what was happening domestically, but nonetheless, I think it does point to the porousness between the external and the internal, which is the main idea. Subsequently, Chinese legal scholars have suggested that racism and exclusion has been institutionalized into the U.S. Legal system. For example, Wang Huning, who now is getting a lot of attention in his 1991 book, America versus America, very much is pointing to the failures of affirmative action. More recently, Zhang Zhigong and other scholars have extended this critique to looking at how the U.S. has been formative of international law and human rights, and pointing to the genesis in terms of the exclusionary aspects. And even more recently, around the same time, very contemporaneously, Xi Jinping and Zhou Qiang and others have critiqued Western ideas of rule of law, human rights, constitutionalism, and independent judiciary, putting forth alternative notions with Xi Jinping's idea of the Renlei Minyin Gongtongti, the community of common destiny for mankind, which is based upon, predicated on this idea of inclusiveness, of win-win, of incorporating the interests and needs of the developing world, the global south, as opposed to just prioritizing the needs of the global north. So the question then for us is, does all of this actually provide a corrective to U.S. racial empire? And I think to analyze that, we have to look at how the PRC legal system is dealing with this notion, again, broadly construed, of difference, how it's dealing with it externally versus internally. So that's the next part here. So I want to focus a little bit, hone in a bit on this idea of the Shirai Fajr, which is a discourse that started roughly 2021, first put forward by the Chinese Communist Party and various pronouncements of Xi Jinping. And it is still formative. It's still being grappled with and defined. So it's a fascinating process to look at how once the pronouncement, the idea comes down, how various actors, including legal academics, are trying to make sense of it. What does this mean? How do we actually use this? And my reading, based upon the Chinese language literature, is it's sort of this commingling combination of what we call, again, private international law, or and the common law system conflict of laws. So the rules governing cross-border disputes, primarily choice of law issues, recognition, enforcement of foreign judgments and arbitral awards, but also jurisdictional matters, coupled with, again, what we call in common law system, foreign relations law, following Curtis Bradley's definition. That's the domestic law of a jurisdiction that governs its relations with the rest of the world. So in the Chinese case, this would be, for example, the treaty-making ability of the National People's Congress vis-a-vis the State Council and clarifying that relationship, which demonstrates some overlap. There have been various attempts to conceptualize what this is and how to fit it into prevailing understanding. So again, in the Chinese discourse, there's this idea of the guonei fazhi, the domestic rule of law. There is fascinatingly this idea of the guoji fazhi, the international rule of law, and then the shuwai fazhi, the foreign related rule of law, sort of sits in between, and it sort of governs the interaction between these different systems. At least that's how I understand it in conversation with Chinese legal scholars and other interlocutors. One understanding from a very extensive report issued by the University of International Business and Economics last year is that it's referring to the country's practice of handling foreign affairs and participating in international affairs in a rule of law way, in the English translation. And I think there's kind of two ways to understand it. I think it's like bi-directional is probably the right way to think about it. On the one hand, you see the integration, the incorporation of foreign law and international law into the Chinese domestic system, but also conversely and concurrently the uploading of Chinese law into, to some extent, foreign law and international law. As Chinese legal scholars have shown, for example, Professor Gu Weixia and others, it's very much about building domestic capacity in cross-border disputes, given, as I mentioned before, the increasing number of foreign judgments and foreign arbitral awards that Chinese adjudicators and arbitrators are dealing with, more foreign law concerns, and you see Chinese legal authorities building out their own institutions to deal with these concerns. So famously, the China International Commercial Court, but also these other institutions, the China-Africa Joint Arbitration Center and the International Commercial Dispute Prevention and Settlement Organization, also in Beijing. So all designed to deal with some of these transnational law concerns, which are becoming more prominent in the Chinese legal system. I think one way to read it is that there's a kind of cosmopolitan logic that underlies a lot of what's happening here. And so the way that I understand cosmopolitanism is that it's an attempt to be ecumenical, to be fair, to be just, to aspire to be universal and inclusive. And it's very much set against, there's clearly a sort of relationship that exists vis-a-vis perception of the U.S. Inspired international economic legal system as hierarchical and racialized. How does that then contrast to or compare to the status of difference organized under Chinese law domestically? So is domestic Chinese law cosmopolitan? Well, again, it's a broad inquiry, so bear with me. But I think there's a number of different ways to think about it. And one way is to acknowledge that there is some success in terms of China's domestic legal reform. And let me just hit on a couple of points. I'm sure people could think about other examples. One would be gender diversity, primarily in the field of arbitration. I attended a conference organized by the Beijing International Arbitration Center back in 2017. And there the director stood up and said, we have successfully integrated more women into our practice. Some 40% of our listed arbitrators are female, as opposed to the international standard, which hovers around 10%, according to this person. So clearly progress in that regard. I think there's probably other examples. Another instance of this relative success is flexible approaches to informal finance, which is huge in China, shadow banking, grassroots courts recognize to various degrees peer-to-peer lending platforms in the underground lending market. There's also a body of literature in the academia that talks about small property rights. So formal recognition, that's formal institutions, including courts, dealing with issues of informal law. And then from my earlier research, there's a limited recognition of what's called qiguanfa, or customary law, in Chinese courts and by Chinese officials. This is usually amongst those groups, or what we call Shaoxingminzu, ethnic minorities, that have a longer history of interaction with the Han Chinese majority. And it's usually in areas of family law and property law that we see this recognition of the customary law. Having said that, clearly there are problems in terms of integrating difference into the Chinese legal system domestically. And let me just hit on a couple of points. Again, people in this room could probably touch or mention a number of other aspects of this. One, I'd say, is the dominance or predominance of male Han Chinese in the legal system, both as adjudicators, lawmakers, but also in the legal academy. One metric is that as of 2019, only 34% of judges were female. There's a disproportionately small number of ethnic minority judges, for example, in the Xinjiang Uyghur Autonomous Region, which has about 60% of the population, which is Uyghur. As in 2016, only 47% of the judges are ethnically Uyghur. There's a problem of non-recognition of religious law. Again, from my previous research, Islamic law in particular is a kind of status of non-recognition in the legal system, as opposed to other legal systems that try to integrate religious law as a foreign law and recognize it as such. And clearly there's a spotty record of protecting rights of women and certain ethnic minorities and the LGBTQ population in China. One example is the stunted or frustrated #MeToo movement in China. So there's lots of examples that one could draw upon. The point here is that when we juxtapose the external facing aspects with the internal ones, we see this kind of divergence. Okay. And so the issue is whether or not that is sustainable in the long term, or what is the directionality of the ongoing reform of these different aspects. Returning to the original question, to bring it back to where we started, can the party state build an ecumenical, plurilegal, and hyper-diverse outward-facing legal system when the domestic one is mainly unitary, homogeneous, and state-led, and potentially increasingly so? I think it's probably fair to say that it's very early days for this Shuai Fajr, so we don't want to be premature in presenting the conclusion. It's very possible that this is going to build momentum over time. That's quite likely. However, at the same time, the current trajectories suggest that the different reforms are moving in different directions. So the external facing is yearning for more integration in terms of foreign international law and the foreign legal systems, whereas the domestic is increasingly closed. And we see this in terms of the partification of many commercial law, the amendments to the company law, kind of legalizing the role of the CCP cells in corporations in China, the data security requirements imposed on foreign companies, increasingly difficult position of foreign law firms in China. Under COVID conditions certainly did not help that there were no foreign law students and scholars allowed in China, so on and so forth. If the divergence continues, then it suggests that the Shuai Fajr will lack legitimacy in the eyes of would-be foreign users. And I suggest that is a kind of existential problem. So last but not least, what are the implications, or what are the possible provocations in lieu of conclusion? I think it's helpful to shift from a purely binary US-China bilateral focus to a triangulated one, to think more fully in terms of the contours and shapes of global governance, particularly in the impact on developing countries, particularly as China is trying to incorporate more legal interaction vis-a-vis developing countries through such initiatives of the Belt and Road and also the Global Development Initiative, which I didn't talk about in detail, but they're certainly there. However, China faces a number of challenges, both ideologically and institutionally. Ideologically, we see this neo-nationalist or hyper-nationalist turn, right? And that is reflected in ongoing reforms, normative, legal, and regulatory. Institutionally, the problem of capacity, right? There's this chicken or egg problem here that China needs foreign talent to build more foreign-friendly rules. So where to start? I think it may be helpful in terms of the Chinese side to kind of scale down expectations, right? So one of the big issues that we've seen is building out these mega discourses that ultimately, and including institutions, building institutions that ultimately more or less are not successful. So I think kind of minimizing expectations would be a helpful move at this point. At the same time, in terms of what the U.S. is doing, the U.S. is sort of drifting in terms of its treatment of foreign and international law issues. And I would suggest, and this is the provocative point, that potentially the U.S. can learn from what China is doing, at least its efforts to integrate more legal cosmopolitanism. However, if it was possible to do so in a substantive way, that potentially could significantly boost the standing of the U.S. in the world, which certainly has suffered in recent years. And I will end on that point. Thank you so much for your attention. Look forward to the questions and comments. Thank you.
Fantastic. So, Jack, would you like to give your comments?
Sure. So full disclosure, I've known Matthew for a while. We met at Tsinghua at a date that I won't say out loud, but predates many of our LLB students' existence. I think that's to put it mildly. And I think in both of our work, we've grappled with this ideas of cosmopolitanism in point, because I think we both value cosmopolitanism, and we've used the U.S.-China relationship sort of as a lever, right? Implicit in this is an argument to try to make, there some sort of consonance between this assertion about what the values of a particular legal system are and how it acts in practice. I think I've become much more cynical about that project over time in my own work. And so I wanted to sort of posit three broad questions in this context. And one is that are the US and China so different, or they're just simply at different places historically, right? So the international economic order was shaped by the United States, right? In the post-World War II era, and common law firms, like from the US, helped shape the rules of the existing international order. So China comes at a time where it's not really trying to change the logic of the system, right? But it's simply asserting its own interest. And these types of reforms are a practical necessity, right, to engage in global economic interface, right? There's no necessarily normative dimension or sort of like counter US in a sense, but it's a practical necessity. So is cosmopolitanism really the right word, right? You have the selective integration, but it's really a matter of sort of catching up to the way in which the rest of the world operates. That doesn't just drive how China relates to the US, but China relates to everyone else in the international economic system, whether it's Australia, Japan, et cetera. So one of the things, and you cite in the paper, Schaefer and Gao's sort of research on the WTO, which is that because China doesn't have international law firms as a private entity, right, to engage in on its interest in the international system, it has to rely upon some of these public-facing projects. The second and sort of furtherance of that question is, well, how much of this is even particular to the US and China, but a natural part of every country's engagement with the international world, right? So in that sense, if there's this tension between how the US represents itself and acts abroad, and there's a tension between how China represents itself and acts abroad, who is actually cosmopolitan, right? The sort of normative compatibility between the external and internal facing legal systems. So if we think about the histories of colonialism, there's lots of extraterritoriality. Those critiques extend into international institutions which span across the planet. And it seems that this sort of altruistic phrasing of power projection is something that every country does to the extent that it can. Right? So you talk that China is caught by the same thing that the US is caught by, where there's a great deal of informational openness. So you can critique the US for being a racial empire, right? But then you have to sort of live up to that in a way when you engage with other racial minorities, either in your own country or in other countries. So is there really something different about how China relates to other countries when it comes to trade, where it's just trying to engage in a type of extractive capitalist logic that requires the practice of certain legal norms? So when you, in the paper, which I recommend to everyone, it's quite rich, you talk about the Fudan Conference, where they're trying to define what is the foreign related rule of law. It's ambiguous and as messy as when anyone in the US at USAID or any other entity tries to define what the rule of law is, right? It shifts all over the place at different periods of time. So in this sense, this language game, it seems to be something that maybe even the US isn't that great an example to think about what China's doing, but maybe Japan, right, that had to enter into the world, right, in a system where at a time when the system was defined, or any other countries, right? If you think about, as a labor person, I always think about Germany, right? And like I work on labor law, so co-determination. Germany has lots of economic democracy to a degree domestically, but it never tries to practice economic democracy or co-determination outside of German borders. So this sort of leads me then to the end about this idea of looking for sort of trends, right? This has been so much of sort of the modernization theory. We're always trying to look at where systems are going or how they're changing. And in the paper, and here you use words like seeds of cosmopolitanism, right? Or in the paper, you talk a lot about the benchmark chambers international, like these types of places where people get together and they're the most cosmopolitan sort of like edge of their legal system, and then trying to extrapolate something from that. Because while decoupling may not be happening in sort of like a crass material sense, right? The type of collaborative legal exercises and the type of people to populate those cosmopolitan institutions seem to be the people who are being crowded out, right, in both systems at the same time. So this this is the U.S.-China framing of this, right? Something that's both probative or, you know, in a sense, all that special. And I guess then the last thing to end with is, and this is something that I've grappled with when I try to make arguments about promoting comparative law in the US, which is what exactly is lost by this contradiction, right? I have always tried to focus on like legal innovation, right? Legal systems become less innovative when they're less cosmopolitan and practice the type of parochialism that the US does. But it doesn't seem like, you know, it hasn't stopped them from becoming a global superpower. It hasn't stopped them from, maintaining their sort of relative superiority in the global economic system. If you have a total, you can say hypocrisy, right, between your foreign and international facing entities, are you really going to be punished by that? Or is it just going to come down to power politics and the ability to project your interests and increasingly realizing that these battles over who's altruistic when they're engaging with China and Africa or US versus Africa really, again, is quite much more superficial than we thought it was in the last few decades. So I think some time for other questions. I'll leave it at that.
That's fantastic. I mean, you did extremely well. Thank you. Okay, let's thank Professor Erie for the wonderful talk, and our colleague Jack for giving this excellent feedback and comments. And thanks to all the audience for coming and being so engaging. And also thank the online participants to this talk. Okay, I will see you guys next time. Have a wonderful afternoon.